desde Las Vegas, Nevada. Iniciamos con el programa Hablando de bienes y raíces con Castillo y sus invitados. Comenzamos.
Good morning, Las Vegas. My name is JC Castillo, and we're getting started here with your program Hablando de bienes raíces con JC Castillo, sus invitados. Estamos aquí desde las estudio de ML Mortgage. Today we have a very interesting program, and I really appreciate the time that the professionals are taking here to be meeting with us. We're going to be talking about probates. It's a infinite amount of information that we need to go through, so we're going to go ahead and get started. We're going to start with introducing Sarah. Sarah, good morning. How are you?
Good morning. My name is Sarah Ocampo,
Yes.
and I'm the owner of Ocampo Wiseman Law in Las Vegas. We're probate attorneys and estate planning attorneys.
Perfect. And also we have here in studio Andy. And Andy, would you please mind introducing yourself?
Good morning, JC. My name is Andy Stahl. I'm a broker of a small brokerage here in town called Raintree Real Estate. And we specialize in probates and trust sales. So this is what we do all day, every day.
Very good. And, most of the people are going to be asking, why is it that we have a a probate attorney and a real estate agent here in Thing? Because you guys work hand in hand. You can't do one without the other. And it's very interesting what probate is all about. So, Sarah, if you want to give me a little bit of background of how long you've been doing probate, how long you've been here in town, and, start giving us some samples of why probate attorneys are so important in this type of scenarios, please.
Sure. I've been practicing law for 22 years, and I've been in town for 24. So I went to law school here right when it opened.
Nice.
We were the third graduating class, so I've been here a while. And as for probate, you were asking me... Remind me.
What is probate? Let's start by just a 30,000 foot view.
Yes, if you could explain what probate is and why is it that, probate attorneys exist? Because I'm pretty sure there's a whole bunch of stories behind that.
Yeah, probate is a very interesting area of law. Mm-hmm. I like it because you're helping people generally, and I like to help people. Probate generally is the court process of transferring the person that died, the dead persons, for lack of a better terms, assets to the rightful heirs, the rightful family members. So when someone dies, a lot of times you're going to have to go to court to get their stuff unless you have the right estate plan in place, and then you could avoid going to court. But otherwise, you're going to court. Your family's going to court. Obviously, you're not because you're not here. Right. But your family's going to have to go to court to get the stuff. And that's the process that we have to go through.
Okay. And that's, again, it has to go through the court system. It doesn't happen automatically. So I'm assuming because we are going through the court system, and Andy, I think you could jump into this. It's not something that happens 1 week after another, right? I mean, there is a process to do all of this, right, Andy?
Yeah, from start to finish, it's over a year. From when someone passes away and you realize you have to probate if there's real estate involved, and you have to, I'll let Sarah go into the details, but there's many steps before the estate is finally finished. And I'll add, because I know you have listeners all over America, this is state specific.
Right.
So I know Nevada state law with regard to probate and specifically selling the real estate and liquidating the personal property, but it's going to be different if you're in California, Utah, Arizona.
Correct. And Sarah, if you want to go ahead and give us a little bit of the background detail of what the actual process will be, right? Let's say my parents are no longer here and we have to start the probate process. How does that get started? What is it that we need to do? What are the first steps that we need to, have ready to be able to contact you and you start helping us with the process?
And like we just talked about, it isn't automatic. Somebody has to start the process.
Correct.
So generally that person's going to be, if there was a will, it'll be the person listed as the executor of the estate. They'll call the attorney, the probate attorney, and say, hey, this person died, we need to open probate. If there's no will, then generally a family member's given the attorney a call and saying, this person died, what do I do? It doesn't have to happen the day after death. It doesn't have to happen the week after death. Sometimes it's literally years after death because sometimes people don't realize that they even need it until years later. And the real example of this, which is exactly what Andy does, someone dies, the only thing they have is a house,
Correct.
right? And they already have, their kid living in the house. So the kid just continues to live in the house when the person dies, even though the child doesn't have the right because they're not on the title, but they just keep living there, paying the bills. Years go by. All of a sudden, they're like, oh, I want to sell the house and I want to move to a different house.
Right.
Well, now they realize they can't sell because it's not in their name. They aren't on title, and they're going to have to go to court to get it in their name, theoretically. So that happens a lot, frankly. I mean, I've had it where it's been 10 years down the road, and all of a sudden they're trying to sell the house and they realize, oh, I can't because I'm not on title. It's not my house.
Right.
And we go through the probate process. Now, it should be happening within a few months of death, but
Right.
There's no punishment if it isn't.
Okay.
If that makes sense.
Okay, very good. And that's really interesting because, like you said, the scenarios vary from families to families, right? Sometimes you have a, family member that's been living in this home, everybody's out of state, all of a sudden there is a death, and then they have to come in and say, whoa, what do we do with this property now, right? I mean, obviously, like you said, if there's a will, it makes it a little bit easier, but it's not as easy as everybody thinks, right? You have to make sure that your will is set up the right way, or your trust is set up the right way to make sure that the transition is done a lot smoother. If not, and let's say there is no will, how or what has been the worst scenario that you have seen in those? And I know you're laughing because I'm pretty sure you have, your
sure
20
we all
and your
have,
20
Andy and I.
plus years of experience. You definitely have seen a lot of scenarios that were like, if only would have been a will, it would have handled this a little bit easier, right?
Yeah. And I mean, I think because with a will, you're still going to probate.
Right.
With a trust, you're not going to probate. So I would say if we're talking about...
Real quick, that's a huge misconception. People
Yes.
think, oh, I have a will, I'm going to avoid probate, and that is not the case.
The will is the first thing that is lodged with the court when you die. Your
Right,
will. Like
right.
literally that's step one of probate. Lodge
Okay.
the will. The original. You have to have the wedding signature. So that is step one. So wills do not avoid probate. You're going to probate if you got a will. And if you have a trust, you might not go. But in terms of horror stories, lots of them. But
Right.
if we're talking about just the importance of a will, right? Because a will tells the world who gets your stuff when you die.
Right.
That's the whole point of a will, is so that the court doesn't have to look at the law to decide who gets your stuff. That's why you have a will. So, the thing that's happened a lot, and I mean, is if the court has to look at the law, they're going to go to the nearest relative or relatives in terms of who's going to get your stuff if you don't have a will.
Okay.
So that takes away some people. I have had a scenario where this has happened a few times where a stepchild is the only person that's around when someone dies. Their stepdad dies, the mom's gone. There's no bio kids. There's just a stepchild, literally nobody else.
Right.
The stepchild calls me and says, my stepdad passed away. What do I do? Well, guess what? You're not a bio child, so you're not technically in the line of succession.
Right.
There is a process in Nevada where sometimes the stepchild can inherit, but it is not automatic. So they're going to be SOL
Right.
if there's no will that says it goes to them, for example.
Wow. That's really interesting because, again, you think that it's automatically, right? I mean, I'm a stepchild. I've been living with these people for 20 plus years and, it belongs to me. But you're right. If you're not a biological sibling or a biological child, there is a process to try to find them because I'm pretty sure there has to be some kind of notification on that, right?
Right. We have to do air searches if there's nobody. And two other examples that are a little different. I had a bio child call me because her father passed away. However, she had been legally adopted out.
Oh my God.
So she was not in the line of succession. She didn't get anything. And we actually thought the state was going to get everything because if the guy that passed away, he was in his 70s, not married, no other child but her, but she'd been adopted, and then his parents were not here, of course, because he was already older, no siblings. So we didn't think there were any heirs. So if there are no heirs legally and there's no will, then it's going to go to the state, whatever the state of Nevada in our case, right? So we thought it was going to go to the state, but we actually halfway through the probate process, because we have to do all these notifications and heir searches, somebody did pop up. It's called in the third degree of consanguinity. We had to do all of the charts to make sure this person could inherit. They were 92 in a nursing home.
Oh my goodness.
But they inherited it at the end of the day. But we had to get the birth and death certificates all the way down the line to prove to the court that they were an heir. But they did get it. Now, in that case, please, if the person who had passed away had just had a will that said it goes to Sally or whoever, then we would never have had to do all of this.
Right. And that's very interesting. And I want to hear from Andy, because Andy, you brought up a really good point. A will and a trust are two different things. And in real estate, it doesn't really, matter which one you have, because the real estate process is kind of the same, because you guys abide by what the court rules, right?
Yeah. And we spoke of this earlier, like, how does this get started?
Right.
Well, when someone passes away and someone's been living in the house or what have you, and then they want to go sell the house, frequently they'll call a real estate agent first. And I'll pull up the ownership of a house and see that, it's vested in Joe and Susie, but Susie passed away. But there's a problem with the vesting, because they didn't own it as husband and wife as community property or joint tenants or something like that. Or Joe and Susie both passed away and the kids want to sell the house, and then I have to say, do you have a trust? Do you at least have a will? Are there any documents available to sell this house? And frequently I'll end up going to a title company to let them look at the situation first and say, okay, it's vested correctly, one of the kids can sell the property. But if not, then I'm calling Sarah, because likely it has to go through probate.
Right. And it's really important, again, to start with the very basics, which is, the vesting, right? And I'm pretty sure, I don't know who wants to take this, a little bit, talk about the vesting importance when you're actually purchasing a property, because that's going to really set you up to less headaches. It's not going to solve your issue, but it's going to give you less headaches eventually down the road. Andy, you want to go ahead and take
I'll start with this? Yeah. And I'll preface it by saying I'm not an attorney,
right? But
I see a lot of, I'm at a lot of closings. And so when the paperwork is filled out as you're buying a property, if you're buying it as a husband and wife, or a boyfriend and girlfriend, or a mother and son, or two friends, how it's vested is hugely important, and it's frequently glossed over at the signing table.
Yes.
Like, okay, it's husband and wife. And I'll tell you, we were talking about some horror stories. So I had one last year where a husband and wife bought a house here in Las Vegas, down by the airport, and when they took ownership in 1987, it was owned by the husband as his sole and separate property. Ooh. Now, there may have been a reason for that. There were some my thought, without having the benefit of him being around to explain it, was that he was a veteran and there were possibly some VA benefits which enabled him to buy the house and have some wheelchair accessibility put in, and it had to be in his name as the veteran. I'm just guessing, speculating.
Yeah. Right.
But they lived in the house from 1987 until he passed in 2002. And in early last year, the wife came to me and said, I want to sell the house. Well, the house since 1987, 5 years, was not in her name. Wow. And I looked at the vesting and I saw, this old handwritten paperwork from the 80s that I'm like, I'm sorry, but you can't sell the house. It actually has to go through probate because it was just in your husband's name as his sole and separate property. So there was a mistake that was made, or even on purpose, but then it wasn't filled out correctly or wasn't handled correctly in later years, where they had no idea that when now, if she had passed away first, it would have been a different story. Right. It would have been in his name and he would have been able to sell the house. But because he went first, it took a year plus to get the house on the market, and get things handled for that family. Right.
And like you said, right, if she would have gone first, it would have solved the issue. But let's be honest, there's no reason, or there's a reason why you guys have a niche market, because usually it happens because people are not aware of what has happened in the past. They're not aware of how they could go ahead and actually include themselves in the title. Because I remember back in many years ago, you could do a quick claim deed and that was good enough. And now the courts are like, no, you need a grand bargain sell deed to make sure that person that's coming on title or getting off title, it is the right person. I mean, it has changed a lot where now you as an attorney has to make sure that, the party that is there in front of you literally has the rights to decide on what's going to happen with that property, right?
Right, yeah. And when I talk to PCs, potential clients in probate, this, honestly, most of the time when someone dies, their major asset is their home, right?
It is, right.
So I'm always, the first thing I'm doing when I'm talking to them, okay, what's the property address? And I look it up on the assessor's page, see who's on title and how it's vested. Because like you said, if there's something called joint tenancy, which is an easy way to avoid probate, at least in the beginning, like the example Andy was making, because if you vest in joint tenancy, it's called joint tenancy with rights of survivorship. So if you're a husband, wife, you're both on title in joint tenancy, one passes, the other one gets it without probate, no problem if you're in joint tenancy. So it happens very, very frequently where we're going through probate because the one spouse isn't on title, the other one passes, and here we are. And now they have to go through it, even though they want to live in it and they don't want to sell it, but now it's not their property. So we got to go through the whole process just to get it transferred to him or her.
Right. And that's a great point that you just mentioned, right? I mean, let's say the husband and wife as joint tenants with rights of survivorship, it's in title, right? I'm no longer here. My wife has the rights. Well, when she passes along and she hasn't set up a will,
then we're back in probate. We're back in probate.
Right. So and then people start thinking like, well, but it's already been fixed. No, it's not, because each individual really, it's a party to the transaction. And as we remove individuals of this title or this vesting, it becomes more complicated because, we've had in the title company come in and say, well, you know what? The mom is buying the property. Well, she says, I want my son to be part of the title. Well, yes, that's a great idea. But is he married? No, right now he's not married. Well, he gets married 2 years down the road. It creates a problem, right, Sarah? Please, can you talk about that?
Well, let me tell you one thing, just because it came up yesterday.
Okay.
I had a potential probate call, and this is also, I think, it illustrates the importance of going to a title company or a lawyer to actually draft deeds, right?
Yes.
Don't do it on your own, because if you do it on your own, which is what happened, this was a handwritten deed. Last year, the woman passed, mom passes this year, a couple weeks ago. She does a deed last year with her son, putting her son and her on title. There's two other siblings, by the way, two other kids.
Right.
She wants, obviously, to give her son the property, so she does this what she thought was a joint tenancy deed. There's no vesting on it.
Oh.
So we're going to probate.
Yeah.
We're going to probate.
Right.
And we're going to probate on 50% interest, because since there was no vesting, that's the other complicated thing, right?
Yes.
So because now it's just defaulting to tenants in common, which means if you've got nothing in there on your deed that says joint tenancy, then it's going to be an undivided interest in the property for that dead person. Again, I apologize for being so, but just to be clear.
No, and you know what? I love the transparency, because, the reality of thing is that when people are sitting in front of you or in front of you, Andy, they're very emotional. They're like, my mom and dad just passed. Now I have this property. I know I'm not going to live in it. I want to sell it. They think they're going to sell it within 6 weeks. And you're like, no. We have to go ahead and contact an attorney. Then we have to go through the process. Then you, Andy, as the real estate professional, you are literally just following instructions, what the courts are saying, because not even the attorney could say, hey, Andy, go ahead and list the property, because they can't. It has to be court approval. Is that correct?
Yeah, you have to, when someone is set up as an administrator for the estate, I can't even sign a listing contract. I can't clean out the house or do an estate sale without the letters of administration from the probate court.
Right.
So I have 2 right now. I think we have that I'm sitting on my hands.
Oh.
Because I can't do anything until we have the letters of administration, and only then am I able to start helping the families get some sort of closure. And that's the thing with these is when you put your head in the sand and you think, okay, my kids will take care of it, my heirs will take care of it, it's doing them a disservice.
Right.
Because you have family members from all over the country, sometimes all over the world. There's of course the family dynamics. We know how it is at the Thanksgiving table. It's not always hunky-dory.
Right.
So there's contention that comes up. There's perceived slights over the years from family members. And, well, I took more care of grandma than you did. And so if you have it all set up in advance, if you speak with Sarah and get everything set up with a trust or what have you in advance, it avoids the awkward, well, no, there's still some awkward conversations, but it helps prevent some of the awkwardness when you pass, and then remove some of that pressure off of your kids or grandkids or your heirs or what have you.
Yes, and no, again, that's really important, right? So we're talking about two different things. The probate process is when you don't have, or you have a will and you still have to get court approval to find out who is in charge to make decisions for you. The other one is a trust. A trust is a little bit easier. And I think that we could go ahead and definitely, have you guys back in here and talk about setting up trust, because that will be the best thing to do. But right now, because we're talking about probates, is, we need to make sure that we think we're the favorite child of the parent. And then during this scenario, we realized we were not, right? And Sarah, I know you're laughing because you have to give that type of, information, right?
Sometimes people, they only want to hear what they want to hear.
Yes.
So we got to, we're still talking about it. In one of my cases, I mean, we've got it's one where we have petitioned the court to approve the sale of the real property. So we have a hearing date in a few weeks. This been going on for like at least 6 to 8 months at this point. And one of the daughters is the administrator.
Okay.
So she's the one making the decisions, hiring the realtor, and dealing with me. And I have had to tell her throughout the entire process. I just had to tell her again this morning, because she thinks that her mother didn't want the other child to get anything. So she keeps thinking she's going to get it all. And I'm like, no. There was no will. The court is going to divide it equally between both you and your sibling. And she just keeps thinking that somehow the court is not going to do that, because again, it was one of these situations where she cared for her parent and the other one didn't, which is great, and legally it doesn't change anything.
Right. So, and I think that's a great word that you just used, legally, right? Because we could all think, hey, you know what, I spent the last 10 years of with my family taking care of them, I should be the one responsible of getting inherited and everything. But legally, the law states, nope, it's 50-50 if there's no will. If there's a will, it makes it a little bit easier. But again, you still have to get involved, right, Sarah? And you got to make sure that you fill out all the right paperwork. I remember that when we did a closing in our title company, and I was telling Andy this, the person that was in charge, they're like, oh, great, so I am going to go ahead and get all those funds deposit into my account. Here's my wiring instruction. We're like, that's a negative, right? And can you explain why that happens?
Yes,
please?
And I'm so glad. I mean, I'm glad you bring this up, because that is another common misconception. Even when I tell my clients verbally and in writing, they think that once the home is sold, because like I said, a lot of times that's the major asset of the estate. Once that thing is sold through probate, then all of a sudden we're done.
Yeah.
No. And they get their money and that's it.
Right.
No. It goes to, generally, it goes to a trust account that's held for the estate. And it's usually through the lawyer's office. So the sale proceeds, like you just indicated, once the home sells through probate, all the proceeds are going to go into my trust account for that estate. And they're just going to sit there until the end. Nobody gets them. Nobody touches them, including the lawyer. And that's another thing. Like, the lawyer is representing the estate and the administrator. So generally speaking, we don't get paid either until the very end of probate.
That's a good
There
point.
are situations where we get paid earlier. It depends, but generally we are literally working for the estate, so we are not going to get paid until we get a court order that says, "Hey, you need to pay the lawyer."
Right.
Nobody's getting paid until the end.
And that's a great point, because Andy, you were talking about right now, you have two properties that you're literally sitting on, but the property needs to be, emptied. And, like you said, you have to hold a estate sale and all of that stuff. And again, the longer that this sits in court, the less time that you have to actually start moving into the real estate action of the transaction, right? So can you explain to us what the process is like if, the siblings or the inheritors are out of state? Obviously, they're not here physically to empty out the house and do all that. You get to do all of that?
Yeah, so that's actually one of my specialties is for where there's, even if there's family in state here in Las Vegas, they still need help. Where do I do anything? So once we get through the letters of administration from the court and they're established as this is the person who's able to sign the listing contract and all that, then I assess the property, and there's 4 decisions.
Okay.
What does the family want? Like, are there family heirlooms or military documents, things, old stuff? Then what can we sell, which includes vehicles, guns, jewelry, what have you? What can we sell? And that money doesn't go straight to the family. It goes into the trust account held by the attorney.
Right.
Then what can we donate? Is there anything that's still useful? And then lastly, what ends up being thrown away?
Okay.
So every property goes through those 4 steps. This takes weeks and sometimes months to do. I mean, I've had some quick ones. We have one right now that it took me a little less than a month to get the house cleared out. That was an 1,100 square foot house. This was a small house with a little bit of stuff.
Right.
So then of course I do my real estate stuff, which is getting the house prepared to list and sell. But then during that process, it's completely different than a normal sale. Like if I were to just sell your house today and you'd have everything ready, we'd list it, we'd sell it, we'd go under escrow and close. Well, no, you have to prepare the buyers that are coming to look at this house that, hey, you can't just buy this house and we close escrow and we're done. You're going to get through your due diligence. You're going to do your inspections, get your appraisal. Then we have to go to back to court and get court approval for it. And I won't even get into overbidding and some of the other items of that unless you have time and we want to.
Right.
But then after that hearing, then within a week or 2 after the hearing, we can finally close escrow.
Okay.
So the one that one of the ones that Sarah and I are working on right now, we went live on Sunday. After 30 days of getting it ready to go, we went live on Sunday. We have a couple offers because the house looks great, like 4 offers, I think.
Okay.
Once we open escrow, we have 2 to 3 weeks where the buyer's doing their inspections and getting their appraisal. Then I turn it over to Sarah to request a petition for confirmation of sale through the court. And it's the holidays, and the courts in Las Vegas are only held on Fridays. Probate court is only held on Fridays. So I've been preparing my buyers that we're looking at realistically the hearing probably early January, and then maybe closing mid-late January, best case scenario. So if you were going to buy your house, you go look at it this past weekend, you open escrow, you're closed escrow by the end of the year, right? You know, maybe the last week of December because of the holidays.
Right.
With this one, I'm thinking like late January, and that might even be optimistic depending on how the probate court gets through the holidays.
Right.
And totally different.
And you're talking about this because of your experience.
Oh, yeah.
Right.
And dozens of these.
So let's talk about experience. I'm a buyer's agent, right? I have a buyer's broker agreement. We say, hey, I know I could get you a good deal in a probate. Wink, wink, right? Because they think they're going to come in and lowball you and say, hey, I'm going to steal this home because it's going to be way below. But your job is to literally list it for what the market value is and try to get the closest offer to that number, right? There's no lowballing. There's nothing special about it. It's, at the end of the day, it's just another real estate transaction. But we have a buyer's agent that is not experienced in this, that thinks that's going to be a quick closing, a lowball offer, and I give my buyer a good deal. And at the end of the day, the reality is not, right, Andy?
Right. Yeah, and it depends on the market at the time.
Right,
because, years ago when there was a glut of homes and then, yes, there was a slight discount, I'd say, for probates because you do have to jump through these other hurdles and hoops and whatnot. But since 2020, when the market went like this, there's not really a significant discount. In fact, with the overbidding process, which I don't want to get into because it's complicated, but once it goes back to the court for that final hearing for the sale of the real estate, in order to protect the families and protect the estates, the commissioner opens up the purchase contract and all the terms and the appraisal for the house and says, okay, I've got a house here. It's under contract at $350, but the appraised value is $400. Is there anybody here in the courtroom that would like to overbid on this house? And it's $5,000 over the contract price. What you're bidding on is the terms of that contract. Well, during the crazy times back in 2021 even, I was seeing overbidders show up at probate court and bid over the appraised value because they knew the values were just going up, up, up.
Right.
And maybe that appraisal was 3-4 months old, done early in the probate process.
Right.
So the investors were swooping in. And so you asked me as a buyer's agent, what am I prepared for? Well, in that market, if the appraisal was from 4 or 5 months ago and it was lower, I'm sorry, you see what I'm getting at? If the appraisal and the numbers were different, then the investors would swoop in and pay more than the appraised value at the court hearing in order to get that house. So you could go all through due diligence, appraisal, and everything, and then your buyer could lose the house to an overbidder. I mean, there's ways to protect your client.
Right.
we don't have more, we only have so much time here today.
No, but that's interesting because, when you mentioned it, Sarah looked at my face. I'm like, I did not know that you could go into the court and overbid if you have the money. Right. And again, like you said, you might have a buyer that's sitting there waiting 6-8 months. He's like, I'm finally kind of purchasing. And then all of a sudden somebody comes in and nope, here's $5,000 more. I'm going to go ahead and take that. I've
seen it.
Oh, and it hurts. Sad. And it hurts, right?
I feel for those buyers because they mentally moved in.
Yes.
And they're sitting there or worse, they're not there. They're not there with their agent. They're not there to protect their contract.
Correct.
And an investor or someone else who wants that house swoops in and for $5,000 more than their contracted price pulls the rug out from under them and gets the house.
That's insane. That's crazy. So again, to me, I've been doing this for a very long time, and that's it. Again, I am not an expert on this. I don't, revolve or involve myself in this type of scenario. So this is the importance of why you need to hire in a professional that knows exactly what it's doing. Even if you're a buyer's agent and don't know, ask questions, right? Figure out. I'm pretty sure, Andy, you're willing to educate them in the process, saying, look, this is not going to close within the next 21 days.
Right.
I could care less how good your lender is. We got to make sure that your lender is prepared to give us, the same interest rate within 9 months, a year. What is the average of once you put it for sale to, when actually you close, an average in the past years that you've been doing this?
Oh, so it's impossible to give you an average because in the past couple years, we've been through, in Clark County, we've been through 3 probate commissioners. And then the court with the pandemic, we were running months and months and months behind. And so at that point, it was very complicated because, like you said, you would look at a probate, but then the hearings were 4 or 5 months out.
Right.
And so by then you had to not reapply for your loan, but you'd have to get the numbers rechecked, re-underwritten or what have you.
Correct.
And then only then could you finally close. So in those eras, that was not pandemic specific. Some of it dealt with the turnover of probate commissioners in Clark County. It was much, much, much longer. Right now, like I just said, we have one that I listed on Sunday. We're going to open escrow in the next couple days because we have multiple offers. And I'm thinking the end of January till we finally close escrow.
Wow.
Till that loan is funded. So it still affects, what's the interest rate for that loan? Did they lock in? Could they lock in earlier? Do they have to wait to lock in because we're not closing till the end of January?
Right.
And we don't know when that final court date is. We don't know when that is yet. We haven't requested it yet. So
right.
There's some unknowns.
Right. Well, now I have a couple of questions for Sarah based on conversation, Andy. One of them is, understanding the timeframes, right? And sometimes you got to ask for a death certificate, right? And it has to be a original death certificate. It can't be a certified copy, right?
Right, and we actually need the death certificate to open probate, technically.
Okay.
Technically, the court will not open until we've got the death certificate. And so sometimes, it takes a few weeks to get a death certificate. And then if there's a murder-suicide situation, it can take months. The court will accept a coroner's letter, a letter from the coroner in those cases. So that helps. But even just opening probate right now, and I'm only talking about Nevada, Clark County, and I know we have listeners everywhere, but the probate commissioner right now is getting better. Like and we're going to have a second probate commissioner, I believe, in January. They're hiring another one, so hopefully it'll get even faster. But just to open probate and get letters, which is what Andy needs to list, and to clean out the property, it's about 5 weeks for the hearing. Then when we get to the point where Andy's in contract and we've got a buyer, then right now we're looking at around, it's actually really good, 3 weeks for a hearing to confirm the sale. So basically 3 weeks, when I say hearing, it's an auction, like Andy was saying. And that's the other thing. I always try to prep everybody involved. Listen, just because, like my client who's the administrator, just because you accept this buyer's offer does not mean this will be the buyer. So please do not emotionally get attached to this buyer. I had one case where they got very emotionally attached to the buyer despite me explaining this might not be the buyer, but they wanted it so bad that they actually did something they shouldn't have done without my knowledge. Their agent, and Andy was not involved in this at all, This was just another agent. They did a terrible thing. They wanted that buyer to buy so bad that they put the buyer into a 10-year lease without telling the attorney or the court or anybody, because they thought if they put them in a lease, then nobody's going to buy with a 10-year tenant. So it actually went into litigation and it was resolved. But please, don't do these kind of things. But just know that the buyer that you enter a contract with in probate isn't necessarily the buyer that's going to win the auction.
Right.
So you can't bank on that.
Right. And that's really interesting because, like Andy said, right now we're not in that period of time where, you have a lot of investors coming into those scenarios. But when the market gets hot, and we know the market is going to shift again. I mean, Andy, how long you been doing this type of, how long you been in real estate?
Almost 15 years here in Vegas.
Okay. So you know that the market is going to shift to a buyer's market, right? And then we're going to start seeing, and then we're going to start seeing this, investors coming in again and everything. So there has to be some kind of preparation for both parties, the selling side and the buyer side, and saying, hey, we might not be the party that ends up, purchasing the property. During the process of you cleaning it out, repairs and all of that stuff, who pays for that repairs? Is it the family that pays for those repairs? Or how does that happen to be able to make sure that we have the property ready and, ready for listing?
It can be the family, but let me just answer one other question. Your previous question about the overbidding and the family that got mentally attached or emotionally attached. As the listing agent for a probate, it's my job to market it all the way through to that hearing.
Right.
And there have been hearings where I, representing the seller and the estate, I send out an email blast to investors with the petition for confirmation of sale, which includes the purchase contract and the appraised value, the date of the hearing, all that, because it's my job to get top dollar for that estate.
Agreed.
And if I think there's still some money on the table, I have to market it all the way to the end.
That's a great point.
So that's a whole other, we could have a whole other podcast about that.
Right.
But to answer your question about who handles the clean out, it's case by case. One of the things that differentiates me from other real estate agents is I'm able to handle that and front the money.
Okay.
For everything from keeping the utilities on at the property. That's huge.
That's
and I'm able to, I have a lot of charities I work with here in Las Vegas that take everything from old electronics to the Association for the Blind to there's a food pantry that takes unexpired food. Just the minutia that comes along with what's in a house.
Right.
I have a car that I'm selling on Bring a Trailer that's going live this week, a fancy Mercedes that I'm selling out of an estate. So I'm able to carry the utilities, handle minor repairs.
Right.
We're not doing full renovation work. The one that we have right now, we did a full interior paint, did carpet in the bedrooms, a deep cleaning, and a yard cleanup. And I'm probably $9,000 into that one.
Okay.
So I'll front the money for the cleanup and the trash out and getting things moved. And of course, handle the estate sale if there's things in it to sell. And then the beauty of me doing it is I'm reimbursed when we close escrow.
Okay.
So for this particular one, when we close at the end of January, say, I'm reimbursed for the utilities and the what I fronted for the repairs and cleanup. If the administrator of the estate fronted the money, correct me if I'm wrong, but they're not typically reimbursed until the probate until the end of the probate, which is now springtime of next year.
Right.
So that's one thing that helps differentiate me is that I take over. Essentially, someone passes away, the family goes through, has their feelings and collects their family heirlooms and things like that. And then they hand me the keys and they start with a closure process.
Right.
And I take it from there.
And I think that's really important, right? Because everybody at the end of the day, we want closure, but this is a thorn sitting in that closure process, right? And having somebody like Andy that says, look, you know what, after you guys go through the property, because like you said, there are sentimental values, right? Like when my wife's grandmother passed away, she left her a small little tin sugar cup. Right. And, she was here. She was, alive when she said, hey, granddaughter, I want you to have this. So she gave it to her in person. Well, a couple of months ago, family member came from out of state and they're like, oh, this is grandma. She's like, yeah, she gave it to me. And she was like, oh, I didn't know that. And those little emotional things is what really makes a big deal. And I know, Sarah, you have gone through those scenarios where the siblings are not even speaking to each other.
Right.
And you have to get them to agree at something, right?
Right. Well, the good news is the administrator is the one in control. So they are the ones that are supposed to be handling everything, including all the personal property, all the little things.
Okay.
If there's no will, and again, we're just going by the court, and we've got sentimental heirlooms and stuff, thankfully, most of the time, people, the administrator is able to facilitate the sale of the, not sale, but the giving of those things, and then everything else is sold, and the proceeds are split evenly at the end.
Okay.
But, I can say that is something that differentiates Andy. It's so easy because I have a lot of people where they pass away and their family's out of state,
right.
And so I get these calls, even out of the country. I've got one right now that lives in Scotland. Their son passed away here, very sad. So they live in Scotland. They flew to Vegas, and now we're handling the probate for their son. Well, they're not here. They don't want to deal with it. It's very emotional. They don't want to clean out the house. They don't want to look at all the stuff. So it is nice because it's almost like a one-stop shop with Andy, because I can just be like, okay, just talk to Andy because I know he handles the estate sales, like everything. And it's easier for me because, of course, what happens is these poor people, they'll call me, the lawyer, and say, well, how do I sell their stuff? Who should I go to? What do I do? Right. And, it's a lot of work for the administrator and the family to go through all the stuff and see what has value and what doesn't, and what we should do with it. Because before we even sell the property, we got to clean it out, right? And we, unfortunately, we've also had a lot of cases where there are hoarders, right? And dealing with the hoarders is a thing, and it takes a lot more money and time to clean that out to get it ready to sell. So at least Andy can help facilitate that.
Well, that's great. That's great because, this partnership that I see between you two, and again, this is the first time I meet you guys, but I could see that you guys work very great together in tandem because, again, without the law side, Andy can't sell. Without the property being ready to sell, you cannot practice your law part. So it has to be a very good, coordination between you two. And, she brought up a great point. Hoarders. I mean, we walked into properties where, there's stacks of stuff in there that you're like, why? But Andy, you have to deal with that. And your expertise, I believe, is that non-emotional part where my job is to get this property ready to sell, right? And then when you have to deal with those hoarder scenarios, how more complicated does it become?
Well, they're extremely complicated because there's, frankly, so much stuff. I've had probates where there's just little hallways, like you see. Oh, the hoarders TV shows. Yeah. I laugh and laugh when I watch those. Really? Because I've seen so much worse than anything you've seen on those hoarder TV shows.
I think you need a camera crew when you have to go through those so people could realize what you have to put up with.
Oh, the before and after pictures on my website, the before and after photos of some of these, raintreelv.com. Great. Click on probate and then look at before and after. You'll see some of them. But there's so much stuff, and I try to be respectful to the family and to the decedent, to the person who passed away, because they collected those things, even though it may be junk to me or you, they collected that for a reason. That is true. And so that's why I try to sell, donate, and then only then trash it if it really truly has no meaning. But yeah, there's a process to it, is taking an inventory of everything. So I have tens of thousands of photographs of my probates because I want to show that this is what I walked in on. I open every drawer and take pictures in every drawer because you don't want something to turn up missing. Grandpa's fancy watch in amidst the hoard turns up missing. So I document as much as I possibly can.
That's good.
And then I have estate sale companies that will come in and help me organize and sell things. And then I personally have 2 trailers that my wife and I and some of the guys that I hire will come and we'll separate it out. Like I said, electronics go to this charity, food goes to this charity, clothes goes to that charity, blankets and towels goes to the animal shelter for the pets and stuff. And so we try to donate as much as we can. And then the last step is getting a dumpster or 2 or 3 or 4 and just making sure the HOA is okay with it. That's a whole other conversation, but then placing a dumpster and cleaning out the house. And then deep cleaning, repairs, paint, what have you.
So literally, it could take 2 to 3 months from the moment that the court says, "Go ahead, Andy, get the property ready." Because before the court says anything, Andy has no right. He can't do nothing.
Right? Nobody can. I mean, the family can't either. Technically, legally. Right. In reality, practicality. I mean, we got to secure the property. And, make sure it's safe.
Yeah.
But
and that was going to be my next question to you guys: is hoarders? How do you feel, how do you deal with those scenarios? Because there's people out there, they're preying on any vacant home.
The squatters.
The squatters,
right?
yes.
Yeah.
Sorry.
And that's the first thing when I'm talking to my potential clients. If there is a property, I ask if anyone's living in the property. Have you secured it? Have you changed the locks? Are there video cameras? Like, what are we doing with this property? Because you're right. There's always the possibility of squatters that we
Right.
do not want.
Nope.
So it's just something that we try to address in the beginning. And I always explain that even though right now nobody has authority on behalf of the estate, whoever I'm talking to is usually an appropriate person to secure the property. Nobody's going to complain
Right.
that we don't, that we've done that, because
Correct.
we need to do it to protect the estate. So.
Right. And Andy, I'm pretty sure you've done scenarios where
Oh.
you walk into squatters.
Oh, absolutely. Yes, many times. I've been there when the police have broken down the door and chased them out. Again, that's a whole other episode. We can talk about squatters.
Yes.
But to Sarah's point, that's exactly right. When you have to protect the property. So I literally have a Home Depot bucket of deadbolts and keys.
Oh.
And so whenever if there's an estate where who has a key? Does a neighbor have the key? Does an ex-boyfriend have a key? Whatever.
Right.
I'll just go and swap out a couple of the deadbolts. Doesn't matter if they match, just to make sure that we maintain access to the house, like who's allowed to be in the house.
Right.
And then once we have an administrator, then we start, okay, well, now we'll have the locks all changed and the administrator gets a key and maybe I get a key. But yeah, I've had the ones where the squatters have broken in because, they see that nobody's come and gone and the lights are off and the gas meter's turned off because the bill hasn't been paid. And so those are the houses that they're looking for
Right.
to break in and squat in. So
Right. And
keeping
it's
the house alive.
Yeah. And it's very interesting that you just said that because, just keeping the utilities up, right? Picking up the mail, it deters a lot of people. And
Yeah.
you want to make sure that, the property is safe. You don't want a squatter to come in and then build a small fire and all of a sudden, poof, the house is gone. I'm pretty sure that, sometime at one
We've
point,
had it, yep.
we've had it, right? So, Sarah, in those scenarios, can you please tell what the court does? Do they just be like, "Oh, sorry, hey, you're lost," or there is a process to get that fixed? Because now we have to throw the insurance company in, and
Right.
if there's no insurance, I'm pretty sure it gets
and that's another conversation in the beginning that I have with my administrators,
Please.
where I talk about the importance of having insurance on the vehicles, keeping it, maintaining it. That is a duty of the administrator to keep the vehicle safe, in good condition, and insured. Same with the home. You got to keep that homeowner's insurance in place because we don't know what would happen. I had one recently. There was a fire at the property. We don't even know who set it. Nobody was living there.
Right.
It didn't kill the whole property. It
Right.
just, it did some damage. So
Right.
there was an insurance claim. We got the insurance proceeds. We still proceeded with the sale. The sale was obviously less than it would have been.
Right.
But, that's what we had to do.
Right. And it's really interesting because, like you said, right, we have to get the courts involved. They've gotten much better because, during COVID, it was a mess. They've gotten much better. Do you see or have you seen that technology has become and has a little bit, eased the process of the probate, or still, we have to make sure that everything is done the right way so the court doesn't kick back anything back?
Yeah. Interestingly, I haven't seen anything change in terms of the court process or
Okay.
anything the court does because of technology.
Well, the Zoom during the pandemic, the blue
Zoom.
jeans and
There
the
you
Zoom.
go. We can, which is great because we're talking about the real estate sales,
Yeah.
in the process through the auction and probate. It's great because you can attend by Zoom.
Yeah.
You don't have to go.
That's cool.
So
Okay.
it's very nice and it's
Yeah.
super convenient for the lawyers.
Yes, of
'cause
course.
we don't have to go to court.
That's right.
Unless it's contested. So that has made it much easier and actually less expensive for the client because we're billing our time.
Right.
So if we have to go to court, that's a lot longer to get there and get back than it is just popping into a video. So
Yes.
that has helped.
That's very true. And then now you just brought up a word that it caught my attention, which is, is not being contested.
Yes.
Can you talk about that, scenario, right? When somebody comes in and says, wait a minute, if I don't speak now, I can't hold my peace forever, right? I have
Right.
to make sure I say something. Can you
Yes.
talk about that contesting part?
Sure. So most of the time we're talking about if there's a will, because if there's no will, then the only thing you're contesting is who's going to be the administrator, who's
Okay.
gets to make all the decisions. So the statute in that case, there's priority for rights of appointment, and it's literally the closest in blood, except the spouses first.
Okay.
So if someone passes away, they have spouse, adult children, the spouse has priority over the adult children to be the administrator of the estate.
Okay.
So that does come up where, so, we'll file our petition and one of the heirs will be like, no, I want to do it. And if you have priority by statute, the court's going to give it to you.
Okay.
Otherwise, not necessarily. One of the requirements in Nevada is you can't be a felon to serve, and that comes up. So, we can't have an administrator that has a felony conviction. And sometimes if you have an administrator that has had bankruptcy problems in the past and some financial issues, sometimes we can fight that and not get them appointed because the administrator has a fiduciary duty, so they're handling money, so they have to be okay with money.
Correct.
But the big deal that you always see with contestations is about the will. So when there's a will, but somebody's saying it's not a real will, like my dad didn't sign it, or whatever, then we have to go through a whole will contest, which is a sort of not a separate proceeding, but it starts before probate, and we have to go back and forth and decide whether the will is valid. The other thing that comes up a lot is when people elderly, right? They all of a sudden they get a will. Now they're giving it all to the person that took care of them. Not good, right? Or did they really have the mental capacity to make that will and make that decision? So that comes up a lot.
Right. No, and that's very interesting because I had to, we're in the title company, right? We sometimes have to be coming up to a deposition about, hey, what was the mental state of this person at the moment that they signed? And, it becomes very technical at that moment.
Yeah.
And, when somebody comes in and, contests the will, it's because, my dad said I was going to be the preferred child, and all of a sudden, why is he handling it, right? And more or less, it's an emotional side, not more than a technical side. And, like Andy and I were talking before the show, is like, everybody thinks that, it's not emotional, but it's extremely emotional because, we've seen families that have been great all the way up to this point, and then all of a sudden they don't talk for the rest of their life. And I'm pretty sure that when you have to go to the closing part of it, having to have all the parties execute that deed or execute the closing, the coordination could be a little bit complicated on your side to make sure that everybody signs, because we've seen scenarios where people till the end like, nope, I'm not signing. I could care less what and it's like, no, the court says you have to sign. So can you talk a little bit about that scenario, please?
Yeah, I mean, in Nevada, one of the if there's an administrator that's out of state, there has to be one co-administrator in state.
Oh.
And so there's always at least one person here, but then maybe you could answer this question. I don't know how to tell if both co-administrators need to sign something or just one.
Oh, that's a great question.
But, so that's, and I'll answer your question, and I'm curious about that. The coordinating, if there's an out-of-state co-administrator, they're at that point, when we have the petition for confirmation of sale and we get that signed court order, that's an order for the buyer to buy that property and for the seller to sell that property. It's an order on both sides to get that done. So usually at that point, everybody's on board to sign stuff. We've worked through the contention. We have clear to close and all that.
Right.
But there's a lot of overnighting documents and e-notarizing and things like that. They're definitely not your standard go into the title company, sit down, sign, and you're done.
Right.
There's a lot more to it.
Definitely. And I don't know, can you answer the question please?
I can, but let me just say real quick, when the thing that I think people also don't understand with respect to families is we've got, 3 kids, mom passes, dad's already gone. One of the kids is now the administrator. They keep thinking and they get pressure from their siblings that they have to make decisions as a group. No, they don't. The administrator is the one that makes the decision. That's the point. That's the only person. So I always remind them, you don't have to do what your siblings want. You don't have to sell it for this amount. You have to list it for this amount in terms of the real property.
Right.
It's all your decision. That's the reason we have an administrator. So only one person's making a decision, not your whole family.
Right.
So that comes up a lot. And I understand the administrator's position is they want to please everybody. But at the end of the day, we got to do what's best for the estate. You got to think about the estate, what is best for the estate. Don't think about what your brother and sister want.
Yeah.
So there's that. And then with respect to who can sign,